tomorrow's oral
Here we
argument.
go.
Oh,
We are
hey,
we are live. All right. Hi, this is Curt,
and Brad Pinsky.
and we're here for another edition of Fire Law Roundup for January 27th of 2025.
Oh, and we've got all sorts of good stuff going on as we try live here.
It's,
So,
it's not the normal setup this week. So
yes, yes. Okay, so let's start in Baltimore. We got a couple of short ones this week. I kind of like it.
yeah.
So I have a hard time with this one because it's always unfortunate, but the law and unfortunate circumstances don't always work out. We're in Baltimore, and the families of three Baltimore firefighters who died in a fire in 22 they lost. They sued, I think, did they sue in federal court? And now
They
they
did.
lost.
I kind of it got a little confusing going back through the records, but they initially filed in federal court. And remember, we talked about in December that they had alleged civil rights violation, that there was deliberate indifference, that the city was deliberate indifference to the safety of the firefighters, and they were trying to use that theory that has been successful by many civil rights attorneys to go after police departments. But the court said that it wasn't going to fly. And the whole reason that I think the relevance of this case to that is the whole reason they did that was because the municipality is going to have certain types of tort immunity. So they didn't want to sue in tort, basically alleging negligence and wrongful death and like that. They wanted to go into civil rights, figuring that they could get around the tort immunity. Court turned them down. Here they are filing now on a tort theory. They included the civil rights, which I'm not sure. I don't understand why they included the civil rights after having lost.
Right. You would think it's what's called res judicata to the viewers. You raised it
Yeah.
in one court, you're going to try to raise it again. You can't do that usually.
And the other thing that surprised me, they didn't allege a state constitutional violation because most states, I'm assuming Maryland, has a due process requirement in the
Sure.
state constitution. So you could have alleged that, fine, we didn't qualify under the federal, we qualify under the state using the same reasoning. They didn't allege that. So I don't know, but I think they're going to be up against that. They've got certainly any sort of sovereign immunity, statutory immunity, they've got to get around. Biggest one is workers' comp exclusivity.
Yeah. Yeah. And although this is probably the fifth biggest, but the firefighters rule still could come into play, though not necessarily for deprivation of constitutional rights, right?
Mm.
Nobody signs up to be a firefighter to have their constitutional rights taken away, but this is a very hard suit.
The firefighters rule primarily protects homeowners, building owners, and third parties. It doesn't really apply to your employer. If they were going against the building owner, then that the firefighters rule would come in.
Right.
It's tough. One of the things, I don't know if you had a chance to fully read the complaint. I kind of perused it last night. It was hard to find. I've been looking for it for a couple of days because this other news channels were reporting this previously. I couldn't get a copy of the complaint. It wasn't available on the either Lexus or the court's website. But once I got it, we're good. But they didn't allege gross negligence or recklessness. And I think that's an unfortunate oversight because I think the facts as pleaded make the case for both of those, either one of those. And those are usually exceptions to
The
sovereign
immunity statutes, right?
and work, and in some places workers' comp as well. In some workers' comp it's not, but it depends. But so they didn't plead that. So I don't know. I don't
Yeah,
know.
it's a hard case. On the facts alone, it's a hard case. But
It is. Yeah.
anyway, we wish everyone the best, of course. Let's go to Louisville. This I love this. It's not where I thought it was going to go. I've been waiting, but everyone keeps settling them. I've been waiting to see what, and I'll get to the facts for everyone in the moment. But to see a court finally address cannabis in the fire service. The problem is I always think that they're going to lose. And so everyone keeps settling it. There is one case, even though it's not this, about that says, well, while the states may legalize it, it's still illegal federally. And under the ADA, you can't claim discrimination for using an illegal drug, controlled one substance drug. It will be interesting to see whether Trump, and I think he does, whether Trump legalizes marijuana. At worst, I think he removes the banking subscriptions, which has been alive in the House of Representatives for a very long time. They keep passing it, just can never get through the Senate. Maybe it'll happen this year. We'll see. But here's what happened. So, and watching the news clip on it is very interesting. If people should go and do it. So the medical cannabis just became legalized in that state. But prior to that, the collective bargaining agreement stated that no one will be discriminated against for using a legal drug. Now, that's why I brought up the first part about the ADA case that because it's legal at the state, still illegal federally. So the term legal drug is a questionable, right, term now. Legal drug where? In any event, so the IAFF local, which I'm really surprised about, but I'm glad about, I'll be honest to explain, but has come out in support of medical marijuana to deal with things like PTSD. And, the head of the union's on the news saying, listen, we need some way to deal with this. He's like, it's not like we're smoking a joint on the bay floor, before we go out on a call. He said, this is, so in any event, but the city's taking the hardline position saying it's illegal federally. We don't care what the state says. In New York, they'd be in a lot of trouble because in our law, modeled after Colorado, California, I think maybe New Jersey, and I haven't looked at this law, but it says no employer shall discriminate. So, I don't know, but here's one of the takeaways. Everybody in their CBA, if your union is going to support legalized marijuana, should look at what you have addressing it and maybe do look, if you don't want to open up the contract, don't, but maybe a memo of understanding, clarifying some terminology. Like in this case, any legal drug, right? Well, legal federal, legal state. Now, this may become moot by virtue of if Trump, and no one said this, he hasn't talked about this, I haven't seen it, but if Trump or Congress does ultimately legalize marijuana, then the term speaks for itself, and I would argue it would be a violation of the CBA. But until then.
Yeah, there's another interesting wrinkle with this, and I don't think it's going to come into play, and I don't have enough of a background pharmaceutically, chemically to really understand all the nuances here. But the test that they're talking about here comes down to they don't test marijuana, they test for THC, and basically metabolites of THC. Well, at one time, anything that produced THC was illegal, because it was basically a cannabis-based product.
Then came the Farm Act.
Then came the Farm Act. And, we've talked about this before. The Farm Act legalized hemp.
And that was Trump.
That was Trump, you're right.
Yeah.
And so if the THC that is in someone's blood or urine, depending on the
hair,
but if it's, if the THC came from hemp, it's legal. So now you're in this, well, how do I prove that the THC that was in my, and some of this may come down to the burden of proof. The city has got if the city wants to discipline somebody, they've got to prove that THC came from an illegal source as opposed to a legal source.
If I was the head of the union, I'd provide hemp soap to every shower, and I would, quote unquote, infest every paid firefighter there. So they're all testing positive. Who can figure out why?
Oh my God. It's just, and this, I hate to say this, there's so many important things that we have to deal with, really important things. And we're debating this one. So
right. And I think what he said comes from a misunderstanding of THC, et cetera. One of the things that the head of the union said, he said it incorrectly, that they can create a strain of whatever to address certain medical states. That is not accurate to my knowledge, but they can address the dosage. So, I have friends who have seizures and migraines who take 0.1 milligrams. It has, which is nothing. It doesn't impair them in any conceivable way, but it's a vasodilator and it seems to fix the migraines and seizures.
Yeah.
Migraines especially.
There's just so many issues here with this. Right. Exasperating.
Yeah. Okay, let's go to Texas. We have a battalion chief who's alleging ADA retaliation, and I will say GINA. We will get to that retaliation. So this is the San Antonio Fire Department saying that, and this is bad, if accurate, that there was a prior Equal Employment Opportunity Commission conciliation agreement, which basically says, okay, we may be discriminating, we're going to stop, and here's what we're not going to do anymore. And it was related to medical examinations. And I think he claimed he was, told he had to do something in violation of the policy. He speaks up about it and is now disciplined, lack of promotion, and then other discipline retaliation. And if the facts are as true, I can't believe this is going to court. You would think they would have just settled that if that's true.
No, I gotta think we're missing something. I don't quite follow why things went the way they did, but we could get into basically what the ADA requires in a test, and if you're gonna, you're entitled if you want to have a medical exam on an entrance or annually. There's nothing in the ADA that prohibits it, but if you're going to use things in that test to basically say you're medically competent or you're medically unfit, there has to be a connection to job relatedness, consistent with business necessity and all those other terms that get thrown out there. And apparently, and I don't know if you read through the complaint, it wasn't specific about what test was the one that they're talking about. And there's another question here that I have about this guy. I can see somebody, let's just call it condition A. Okay, so somebody's got condition A. Okay, they would then have standing to file a suit alleging a violation or potential violation of the ADA. Okay. But what if the person does not have condition A? And now they're suing, saying, you're making me take this test.
Which could reveal condition A.
I don't have condition A. And, it's a little bit ambiguous, but what's clear here is that if I don't have condition A and I'm complaining that you're testing for condition A, and then I'm retaliated against, I can still be a whistleblower.
Yeah.
But I may not have that substantive standing to challenge. I don't know.
Unless, remember, if they're specifically testing for a condition, then maybe you are perceived as having, right? Maybe perceived as having it. Or maybe we're just trying to not perceive you as having that a condition. Yeah, you're right. It's a harder case. That the discipline I thought was really funny though. One of the things they did to him that he alleges is, and this is the problem because it's so far-fetched, it raises the real possibility that maybe they were retaliating based on something. They send him for a drug test, quote unquote, a random drug test. I don't know how many are in the random samples, but I presume there's a ton of people he happens to get, and I don't know how many else got selected, right? But so first in dish, okay, he was selected. Was it truly random? But then the problem is he was actually selected like 3 or 4 months earlier, and then they show up at a Sunday at 5:30. And I'll explain why that's important. And they have somebody show up his house, I guess, or something, Sunday at 5:30, wherever he was, and say, okay,
he was in a firehouse. Yeah.
Oh, firehouse. Okay, right. Yeah. So, and they say, okay, now you got to do the test. And it was 3 months old if it was truly random. It was a long time ago. Why is it coming up now? You can't do that. You can't, if you guys draw a random test, you do the test immediately, right? You don't give someone 3 months because, and not for the reason of this, although it's not a bad one, but really the reason is so you're not giving people time to clear their system and there's no, hey, you just got selected, none of that type. But what's worse here is based on the facts, they have the right to get their own doctor to do a sample if they can get a hold of them with X hours. But they said they did it Sunday at 5:30, so it'd be impossible to exercise that right. And they basically, fact him out. They used facts. They used a scenario that wouldn't allow him to exercise his rights. It just, right? So yeah, listen, it's hard to argue you're retaliating if there's nothing to retaliate against. But when you do acts that looked retaliatory, you start wondering, maybe they are.
Yeah, I would think and especially, the fire department they've got to realize that the EEOC is involved in this case. You've got a conciliation agreement. Number one, you didn't comply, or at least according to the complaint, you didn't comply with the conciliation agreement.
Right.
And number two, you went after the complainant who raised the issue. I think that, you know, if there was indeed retaliation, there's going to be some consequences, not necessarily from the case. It's going to come from the EEOC.
Yep.
And, you know, very often when these types of things happen, it's the U.S. Department of Justice that steps in and says, no, you don't even have to be the complainant. We will be the complainant for you. And we didn't see that here. So again, I think there's a lot of open questions.
Yeah, agreed. Okay, in what I call the case of the day, and I was so interested in this, I started doing a lot of legal research. We're in Iowa. We have a paramedic who's facing manslaughter charges because they had a patient who was, quote, freaking out and laying in the street rolling around. She thought she administered ketamine, which would have been proper, but actually gave Recuronium. I've never even heard of that. It's paralytic, so I presume it's to intubate
I hadn't
somebody.
either, and I checked with, I don't know if you know this, but Fire Law Group has a resident physician.
Of course.
I checked with Dr. Varone,
Yeah.
and he gave me the full insight, but go ahead.
I presume it's a paralytic to intubate you. I use different
Exactly.
names, but maybe it's just another name of another drug.
It is.
But in any event, so paralytics are normal, but they don't normally kill you. To my knowledge, in any event, she gave probably the ketamine dose, right? And she injected it, and the patient died. Now, then there's one other part, but this is important and not important. But she didn't notify anyone or treat the patient any differently. So any reversals, drugs, any notification of the hospital, I just did this, you need to do something. So that's the fact that's going to be problematic. So they charge her with manslaughter. So I looked up manslaughter in Iowa because I was very interested in this because it matters. And there's obviously two types of manslaughter in Iowa, like many other states, involuntary and voluntary. This would fall under 707.5 involuntary manslaughter. And this is what it says. Two things, very interesting. A person commits involuntary manslaughter when the person unintentionally causes the death of another person by the commission of a public offense other than a forcible felony or escape. So if you stop there, okay, well, the first thing I'm like, wait a minute, how is there a crime which is not intentional? Right? Mm-hmm. Normally, we talk about recklessly. We don't just say they unintentionally caused the death, right? We said normally manslaughter, we say they've acted in such a manner which is so likely to cause or bring about the death, right? But here it's just unintentional. Frankly, if it was me, I'd be arguing, if it hasn't been raised 10 million times already, that this is an unconstitutional provision. But that, assuming it's fine, then the next is by the commission of a public offense. So I haven't read the charges other than manslaughter, but you wonder what the public offense was. And again, offense against the public, I don't know that giving the wrong drug is going to constitute. So I don't know how you get to involuntary manslaughter here, honestly. Look, I think what they did was horrible.
There's also a common law involuntary manslaughter. And I'm assuming Iowa is a common law state and they recognize common law involuntary manslaughter. And involuntary manslaughter, common law, is consciously disregarding a known and substantial risk of harm.
Right, the reckless standard.
Right, exactly. So, but I forget if this was the case. I think this may have been misdemeanor manslaughter, which may be one of those statutory provisions.
Well, I thought it was felony. I looked up felony manslaughter, but I could be wrong.
Well, usually manslaughter is a felony. And I'd have to go back to the original article. Let me see if I can get to it right here. It looks like at least on my end, the video that was there did not embed properly, but
it was there because
yeah, it's an aggravated misdemeanor.
Oh, okay. So aggravated misdemeanor, I have that, is when the person unintentionally causes the death of another person by the commission of an act in a manner likely to cause death or serious injury. So probably the reason they didn't get felony manslaughter is because of the above issues, we talked about, right? Mm-hmm. There's not really a commission of public offense, but here, an aggravated misdemeanor, when the person unintentionally causes the death of another person, that's this, by the commission of an act in a manner likely to cause death. So, and that's more than just so likely to, right? It's more than reckless, but it's likely, or maybe it's less, I don't know, but likely to cause death or serious injury. So this was that. here's the thing. I don't think it's the drug administration that necessarily is the manslaughter. I think it's not reporting it. But if the person would have died anyway, then maybe the reporting of it doesn't matter. I'm not trying to be this person's criminal defense attorney, but
no. But I thought she did tell hospital officials.
According to the court documents, it says she did not take the appropriate steps to notify anyone or treat the patient any different.
Okay, so I mean that's a problem. Now, a couple of issues here. Normally, this is administered IV, so it's right in. She did it IM, and so it's possible, and I'm just trying to get into her mindset. That she said, okay, it's not that big a deal because I did it IM. Let's get him to the hospital, and hopefully it won't be too bad. Yeah, when I spoke to Dr. Verone, he said that this as a paralytic agent, exactly as you suggest, it basically, if you're going to intubate, it allows you to intubate, and they're not going to be able to really resist it. But they're going to be conscious. Right. So they're basically consciously going to be suffocating if they're not able to breathe. And so now the patient may have had some other things going on. Obviously, he's acting a little bit weird. But point being, I think, she may have a defense there that she didn't, like, it wasn't like she administered IV so that you knew it was going to take the normal route. Right. So it's another reason why my son, he was a firefighter, and he was, served on ambulances and everything. We didn't have, he wasn't a full paramedic. He was an EMT cardiac, we call in Rhode Island, does a lot of those things. But he's expressed concerns about paramedics, despite having all the training that they do have, not fully understanding all the biochemical things that are happening. And, like a doc would be able to, and I'm not, I certainly can't do this, but able to evaluate what's going to happen when you give a certain dose of this paralytic IM as opposed to IV. So, whereas a paramedic may not be able to. And whether that may pose a defense, at any rate, they didn't properly, this could have been resolved. There's a couple of things that she could have administered. There's a couple of things, certainly maintaining the airway and, keeping the guy properly ventilated may have resolved it as well. So
right. And just on the paramedic side, I don't know if they're trying to do RSI, rapid sequence intubation. Theirs, we usually use the paralytics. Well, what we use, at least in our, is called SUX, SUX, but sucks in chlorine, I can't even pronounce it, or etomidate. But they're all paralytics, and they all are used for intubation. It's very common with rapid sequence intubation, but you got to check the meds. I mean, forget, anything else. You got to check the meds. And right. I'm just curious, was it so hectic? Was it dark? Was she, what was the situation that caused her to grab the wrong one? And had she just told somebody after, like, oh my God, if she knew, I think
she knew, but I look at what we're talking about here is really important. I call it like a C-level approach to what happened at the incident scene. And I think if we take the 50,000-foot view of this, which I think is important, this in conjunction with several other cases that we've had over the last few months raises some concerns, because we're seeing medics, firefighters charged criminally. Yep. And we've seen it before, but it just seems like we're seeing more of it. Yeah. And is this sort of a manifestation that you can't make mistakes? If you make mistakes, we're going to hold you accountable. And we're not just going to hold you accountable financially by suing you civilly. We're going to put you in jail. And at the 50,000-foot view, we got to ask ourselves, do people want to expose themselves to this kind of a risk?
Right.
If you make a mistake, and mistakes are going to happen, we try to minimize them.
I try to driving engines and trucks.
Right. But, and I joke, but I joke, but I'm not joking. One of my neighbors is a librarian, and a librarian makes a mistake, and the wrong book ends up, or a book ends up on the wrong shelf. Okay. We make a mistake, and people end up in caskets, and, so there's serious consequences to our mistakes. We want to minimize mistakes, but is it from a 50,000-foot view, is it really advisable to start putting firefighters and medics in jail when they make a mistake?
Right.
You know, I've got a big
It wasn't
concern.
intentional. I mean,
Let the civil system work itself out. Absolutely. Let the discipline process, they get fired and so on. Putting them in jail, what are we doing?
right.
I mean,
And let's
what are
look,
we doing?
meds are never supposed to look alike, but vials do look alike. And right. So whatever you say, vials look alike. Pre-filled syringes, if that's what they had, look alike. You know, and you try your best so they don't, but in the dark, in the field, you got a little narc box, right? You pull it out either of your bag or maybe it's on your person or whatever. You're pulling it out. You're trying to administer it. You've got here a patient who's clearly, right, causing a hectic scene. And how do we, you know, how do you blame somebody for, as you said, make a mistake? This isn't like the OR where you've got 10 million people repeating everything, right? Because when they do it, they hand to a drug, somebody reads it, right? In the OR and the ER, they read it, they confirm it, they document it, then they hand it to the doctor to administer it. And it's right. And we don't have that luxury.
No.
I think your point is right. This should be this should be the same outcry, I think. Again, except for she didn't tell anybody if she should have, right? Or
And that's right. And that's a fair point.
right.
You know?
I think that's the problem. But this really started back at Lairdsville, New York. And I remember all the videos, I still have them, where there was such a huge outcry that the DA would go after a firefighter for something like this. And it started there. There really wasn't much before 2002 that I recall. Of course, I would be a young attorney at the time. But I don't recall any major cases.
There's been a couple. But he was the first that I know that actually served prison time. You know, I actually did a study on that, and I went back actually after the Iroquois Theater fire. Go back to Chicago and the Iroquois Theater fire. They indicted the mayor, the fire chief. There was a fire detail at the theater he had taken a little siesta, and he was not where he was supposed to be at the time of the fire. There was a bunch of things, but no one was convicted. They were not convicted.
Right.
After the Coconut Grove fire, they wanted the mayor, the fire chief, several of the other
Right.
high-ranking people, the fire marshal, to be charged criminally. So there's a history there, but I don't know. It just seems like those are incidents where there's mass anger directed at
Right.
us in the fire service. We saw it after the Station nightclub fire, so the same kind of anger, but that was a mass incident. These are one-offs. The incident in Aurora, Colorado, with the ketamine administration, that was a one-of. Certainly not one of, and I certainly don't mean to trivialize it, but when you have 600 people die in a theater fire,
Right. Very different.
There's a different type of public outcry, and
Oh, you're going to see it in LA again right now. You're absolutely going to see it. I will have no doubt that they'll go after the fire chief or the mayor or whoever for the lack of conservatory efforts to prevent all these wildfires. But okay, let's end up in Colorado. I think I can summarize it, but I'm going to pass the ball back to you. In short here, Colorado have a Fair Labor Standards Act violation. They're claiming they're due overtime in very simple terms because they claim there was no work week set. And there are some courts, and pass this back to you in a second, there are some courts that have acknowledged that the failure to set a work week on agreement or policy will lead to, okay, now you have a 40-hour work week and now you've got to pay. If I'm right, they were doing something out of 1 month calculation of overtime. I pass back to you, but holy cow, who today doesn't know that minimum, right? The 7K exception at a minimum, but I'm surprised the union never brought it up beforehand.
Yeah, I'm not sure there is a union, but it appears to be a relatively small fire district, and they apparently weren't paying their firefighters overtime. Now, you know, I don't know if this fire department qualifies. There is a thing called the small fire department exemption, and in order to qualify for the small fire department exemption, you can only have 4 firefighters. if you have more than 4 firefighters, more than 4 employees in fire protection activities, that's the term they use,
Right.
then you don't qualify. So you got to have 4 or less. Okay. So my guess is the department had more than that, but maybe at one time they had 4 or 3,
Maybe I
and
passed over. Yeah.
I think this is very common, particularly in small departments where we've always done it this way. We don't have our own HR, we don't have our own legal. We just kind of, fly it, and I'm the chief and I'm doing it the way we've always done it. Bottom line is they were not paying them overtime. They paid them straight time for everything. Under the FLSA, if you do have firefighters, you can take advantage of the 207K exemption, which allows you to not pay them overtime. If you choose to go on a 7-day work week, you pay them overtime after 53 hours. Most departments choose to kind of spread that out. They'll go up to a 28-day work period, and then there's a ratio, the same as 53 to 7. It's 212 to 28. So if you don't follow that, you can kind of read up a little bit on the article there. But there are some courts that have held that if you don't designate a work period, you cannot take advantage of the 7K exemption. And if you cannot take advantage of the 7K exemption, you're stuck with paying your employees overtime after 40 hours on a 7-day work week. And that's a pretty serious. I mean, it's going to be costly for them to pay them overtime after 53 in a week, but obviously overtime after 40 is going to be, it's going to be more costly.
Absolutely. And if anyone, one of you are watching and you're like, gee, I wonder what our pay week is, start with the CBA or your policies, but this is a big deal. And I think the courts in that holding are right, who follow that line. If you haven't declared it, you don't get to pick and choose your work week. And the work week is a mandatory subject of, bargaining. So you don't just get to pick it and not announce it.
Well, it's funny. The regs seem to suggest that you have to select it. The FLSA itself does not. So that's, I think, where the courts are kind of leaning toward the Department of Labor's interpretation, which is in the regulation, saying that you need to designate, in order to take advantage of it, you need to designate your work period. And if you don't have 7K. You can't take advantage of it. So
I
don't
agree
know.
with that.
There's the principle in the law is that, as long as you're an employee subject to the FLSA, that's all. As a plaintiff, that's all you have to show. I'm employed, we're in commerce, or we're a public agency, the FLSA applies to us. It's the employer that has to prove that they're entitled to an exemption, including 7K. And so the fire department here has to prove that these are employees in fire protection activities, number one, and that we have adopted a certain work period. We have adopted 7K. That's where the department may have a problem.
Yeah, and I wonder if you could do it by tacit agreement. Normally you can. Normally you can show, well,
Yes,
the past practice, everyone's been paid like this, right? And it's just that when I get to, well, wait a minute, it has to be a subject of mandatory bargaining. Can you really work your way into it just saying past practice?
Well, you can. And what the courts will look at is, are you looking, this is what they'll look at. And there's a bunch of cases on this, okay, where a fire department adopts a 28-day work period. So they formally adopt a 28-day work period, but never in the history of the department have they ever actually looked at a 28-day work period and paid people overtime based on that. They just pay them overtime whenever they work on a different shift.
Oh.
And so, so if you're on A shift and you work an extra shift on B shift, they pay you overtime. And if you work on C shift, they pay you overtime.
Which probably captures most of the overtime needs, but that's
It does, but you can't say we have a 28-day work period and never go back and look at the 28-day work period.
Right.
Okay. And the same thing. And some departments actually go back and they do look at it, but they look at it on a 14-day work period. So they say they have 28, but they actually do 14. And the courts say, you got a 14. You can say whatever you want, but by practice, you're using a 14-day. Okay. Wow. And vice versa. There's all different ways to do it. Okay. But what you want to make sure you're doing for the fire chiefs out there, you want to make sure that you adopt that work period and then you actually look at it. And this is going to be a pain in the butt. When you tell your payroll people they got to do this, they're going to go, what?
Right.
We
Right.
did
But
it this
there's
way.
software that does it. It
Yeah,
calculates it.
well, none of the software really does it well for fire departments, believe it or not. Because you think about most employers have to pay overtime after 40 hours in a 7-day work period. Nobody really has a good system or perfect system that incorporates all of the 7K.
Okay. I was going to say, so when I was chief, one of my, he was the head of our ambulance, Kevin. He was a programmer or very software engineer or something at Lockheed Martin, very smart guy. And so he programmed an Excel spreadsheet for me that calculated all the overtime and then divided it into what time it was. So for budgeting purposes, if I knew I had somebody out at classes or doing fire prevention or ISO inspections or whatever they were doing, I had that time so I could budget for next time. But it was really neat because every firefighter had to enter their time, right, individually. If they were overtime, the reason for the overtime, etc. I mean, it was great. And I guess maybe to the point, maybe I wouldn't have had to create that spreadsheet if we had something that did it. Although, our village wasn't going to spend the money. We were.
Let me ask you this. Were you paying overtime after 53 hours or 212, or were you paying over 40?
No. At that time, they're 53.
53. Okay, yeah. So that's a pretty if that system works and takes into account all of the wage augments and different things and acting on a rank, if it does that, there's a market. There's a market for that.
Oh my God, it was such a really? That's funny.
Yeah.
He can custom program
Get him on the phone. Get him on the phone.
If anybody's watching, I'll get back in touch with him. He can custom program it. But I got to tell you, what we have was phenomenal. And I could tell you your guaranteed stipends that went into the wage augmentation. I could tell you when they kicked in. We put in when seniority kicked in and it automatically increased it, right? We had when everything that could, it's a great, I probably still have it, but if anyone wants to hire the guy, I'll see if he still wants to work. But it was brilliant. So maybe you're right.
You can retire from the fire department and start doing that. Cause I'm telling you, there's a market for it. Cause none of the big payroll systems work.
Oh, wow. Right. Cause they're not built for firefighters.
Yeah. So.
Oh, well, I got to think about it. Okay. Well, that's it for the week.
All right. Well, that'll do it for another edition of Fire Law Roundup. If you haven't already subscribed, please subscribe. If you can help us. I was doing a little bit of reading this past week, and apparently the algorithms for YouTube are really helped out if people click like. So if you can help us out by subscribing and clicking like, it's going to help us increase our viewership, and it'd be important for us. So
awesome.
Right, and that'll do it for another edition of Fire Law Roundup.